Good morning, everyone. Welcome to Introduction to AIPRA. We hope you all enjoy this. A couple of announcements before we get started. This is a CLE class, so any attorneys, there's a sign-up sheet up in the front, right on the table. You can put your name and bar number, and that'll work on getting you the CLE credit. Today, we are doing lunch on our own, so no gathering in the main hall for lunch. Also, I just want to remind everybody, it's very helpful for us. You see the little blue cards on the table, the evaluations, that really helps us a lot. If you could take a few minutes at the end of the session to fill those out. Okay, so without further ado, I'm going to introduce Professor Casey Ross. She is going to come up here and tell you all of her wonderful accomplishments, which there are many. I mean, I could stand here and read them, but it's more interesting coming from her.
Thank you. Thanks. Well, good morning, everyone. My name is Casey Ross, and I work at Oklahoma City University. I teach in the American Indian Law program at OCU Law, and I think most pertinent to the work that we're going to be doing together today, I am the director of our American Indian Wills Clinic. So in that clinic, we provide estate planning services for American Indians in Oklahoma who own an interest in trust or Five Tribes restricted property. And we work with law students to teach them how to practice law, and we have them to represent actual clients under the supervision of a licensed attorney. So I've taught that American Indian Wills Clinic for a number of years. We're actually on our 10th year, which is really exciting. And we never run out of clients. It's very interesting, right? There are just a whole lot of implications that occur as a result of the American Indian Probate Reform Act, and we just never are going to run out of clients because there's such a need to draft wills to kind of avoid how AIPRA treats Native property. And we're going to talk a little bit about that. So before we get started, I just want to kind of get a feel for who all's in the room. How many attorneys do we have with us? If you're a lawyer, go ahead and raise your hand. Okay. Are you writing American Indian wills as part of your practice?
Not currently, no.
Okay. Okay. Do we have any folks who work at the Bureau of Indian Affairs in the room? Okay. Are you guys on the probate side? Are you? Okay, great. So we may have some questions for you here in a little bit. Perfect. Okay. Oh, thank you. Thanks. So, okay, we're going to spend some time this morning talking about just some very basics of the American Indian Probate Reform Act. So if there are any of you in the room who work with this on a day-to-day basis, it's going to seem very, very basic to you, right? But feel free to chime in, feel free to ask questions throughout the presentation, because what we're really going to try to do is just get a baseline understanding of what this statute does for purposes of governing how American Indian property is treated, okay? So I want to spend just a few minutes talking about when AIPRA was passed, right? So the American Indian Probate Reform Act was passed by Congress, and it actually was passed after a couple of different iterations of the act, right? Preliminarily, whenever the act was introduced by Congress, it didn't pass that time, but it was introduced. AIPRA was actually going to also cover Five Tribes property in the state of Oklahoma, but Congress responded to some concerns that were brought forth by oil and gas interests in the state and actually removed the Five Tribes from coverage in this act. So this act is only going to apply to trust property, right? Are there any folks from Oklahoma in the room? Okay. So you guys know it gets crazy there, right? Whenever you're trying to work through whether it's trust property, whether it's Five Tribes property, whether it's Osage property. But interestingly, this act doesn't apply to Five Tribes and Osages. So, okay, so when Congress was working towards passing this act, it was really in response to a lot of concerns that had been brought forth about the ongoing fractionation of American Indian land, right? So when we think about how Congress tried to address it over the years, you guys will recall that we had the Indian Land Consolidation Act. It was struck down by the United States Supreme Court as being an unconstitutional statute. Congress tried again with an amended version. That went to the Supreme Court and was again struck down, right? So AIPRA was kind of the last shot that Congress had to try to get that Indian land consolidation stuff right. And thus far, it has stood. So let's talk a little bit about what Congress was trying to address. One thing that I might recommend, if you have occasion to read the Supreme Court case Babbitt versus Yupi, there are some really interesting statistics in a couple of the footnotes of that Supreme Court opinion that talk about the number of American Indian trust interests that were being managed by the federal government. It talks about the cost of managing those interests. It talked about, it's kind of interesting, but it talked about some interests in trust property had become so fractionated that the income that was derived from the property wasn't enough to cover the stamp that the federal government had to put on the envelope to send the check for the payment, right? So that case really does highlight a lot of those concerns that Congress was trying to alleviate. And what's interesting is that case was quite some time ago. So when you think about how fractionated the interests were then, imagine that just getting exacerbated over time, because it certainly did. And then we had AIPRA come along to try to fix some of it. So how many of you have read the AIPRA statute? I recommend it if you're ever having trouble sleeping. You can open that thing, you can read it, it'll put you right out, okay? When I teach this in law school, what I ask my students to do is I ask them to go ahead and read the statute. It's not the most entertaining stuff that you'll ever read in your life, but it's helpful to kind of understand how Congress was putting the stuff together. In addition to the statute, it's also helpful to look at the regulations that were promulgated by the Department of Interior in response to the statute, because those set forth a whole lot of the nuts and bolts about how this stuff works out. So we may reference a couple of those different things throughout the course of the day. So when Congress passed AIPRA, they set forth in the statute itself what their findings were about kind of, the need to pass a federal statute that would address this ongoing crisis of fractionation. So Congress just spells it right out there in the statute. There is increasing fractionation. It's not stopping. It's getting worse. Interestingly, because before AIPRA, right, before AIPRA, if you owned trust property in the state of Oklahoma, when you passed away, it was going to be subject to Oklahoma state law for purposes of intestate succession. If you owned property in Montana, it was going to be under Montana law. There was just no uniform approach for dealing with anything that had to do with how trust property would be treated after the owner of the trust property passed away, whether by intestacy or by will. So Congress really wanted to look at implementing something that would be a uniform probate code that would apply to American Indian land interests across the country, so that there wouldn't be this kind of misunderstanding or this different treatment of different parcels of trust property from one place to another. Keep in mind, whenever you look at the statute, there are a lot of exceptions where AIPRA doesn't apply to specific tribes. So make sure that if you're working with a client who owns trust property in a tribal jurisdiction, that AIPRA actually applies to most, right? But there are some notable exceptions. The 5 tribes in Oklahoma being one, Osage in Oklahoma being one, and then some additional tribes, Alaska Native villages, also not being included in AIPRA. So double check and make sure it applies, but that's something to keep in mind. So Congress wanted to make this uniform probate code that applied to all Indian trust interests, except for those, kind of strange exceptions. Congress set forth in their findings that probate planning is very difficult, that it's a difficult process. It was very, very difficult to understand how to work through different states' laws and different states' processes to get an Indian trust property interest probated. And Congress set forth findings that tribes, have the ability to go ahead and implement their own tribal probate codes, okay? Tribes have that authority. It's a sovereign right. It's never been impeded by Congress, right? So in AIPRA, what Congress did was Congress said tribes have the ability to pass their own tribal probate codes, but pursuant to this federal statute now, there are some additional requirements imposed on tribes who want to try to do that, right? So Congress, said, hey, we've taken a crack at drafting a uniform probate code that we think makes sense for trust property. However, if a tribe determines that they don't like the way this uniform probate code we've put together treats the trust property in their jurisdiction, the tribe has the authority to go ahead and pass their own tribal probate code that would do things differently than how the federal uniform probate code does it under AIPRA. And so Congress set forth in their findings that was one of the purposes of AIPRA, was to try to facilitate tribes being able to pass their own tribal probate codes. Any questions at this point? Okay. So Congress was very interested in making sure that that uniform probate code would help out the way that they anticipated. They wanted to put together a law that made sense to be able to reduce the number of fractionated interests, to try to get folks to think about writing wills and going through an estate planning process. Also to help with facilitating the creation of tribal probate codes. And then again, just getting that process down to something that made sense across the board, right? Instead of probates going one way in one place and another way in another place, the idea was really to try to make that all kind of uniform, to make it go more quickly, and to make it help with the fractionation problem. Okay, when you read this federal statute, it totally gripes me, actually. When Congress wrote this statute, they wrote the meat of the statute up front and they put the definitions at the end of the statute. Well, you're going to fall asleep before you get to the end of the statute and read the definitions because the front part's kind of boring, right? So if you want to know the definitions, you actually have to get all the way to the back of the statute because they put it at the end for some reason. And I don't like it when they do that. I'd rather them put it at the front, but it's a personal preference. So Congress set forth a number of different definitions that apply for purposes of American Indian Probate Reform Act. And I want to talk about just a few. These are not all the definitions that are contained in the Act, but they are a few definitions that I think are helpful. So when we teach in federal Indian law, we teach students, what the definition is of the word Indian or American Indian Alaska Native or any other specifically federally defined term that applies to Native populations. And when we teach that, what we have to tell students is there are over 50 definitions in federal law of the word Indian, right? So if you go look at any particular statute that applies in Indian country, you're likely to find some difference of definition as opposed to another act that you might look at. So when we talk about the definition of the word Indian under AIPRA, it's important to understand that this looks a little bit different than the definition of Indian, say, under the Indian Healthcare Improvement Act or the Indian Child Welfare Act, right? The term Indian is defined kind of specifically and differently in AIPRA. So the definition of the word Indian that's included in the Act actually takes up a few slides in this presentation. So obviously, number one, anyone who's a member of a federally recognized American Indian tribe, any person who's an owner of a piece of Indian land, or a person who meets the definition of Indian under the Indian Reorganization Act, which is another federal statute that was passed in 1934. Congress oftentimes will throw back to that federal statute because it had a pretty holistic idea of what an Indian person was as of 1934. Just for ease of reference, I've put it on this slide here. The Indian Reorganization Act defines the term Indian to include anyone who is of Indian descent, who's a member of a recognized American Indian tribe that's under federal jurisdiction, people who are descendants of individuals who lived within a reservation boundary as of the date of the passage of the Indian Reorganization Act, and then individuals who are half-blood or more. There are also specific definitions under the Indian Reorganization Act and subsequent federal statutes for Alaska Native individuals. There is a separate bullet point under the definition section for the word Indian under the Act that applies to individuals who are in the state of California. How many of you guys are from the state of California? Okay. So you probably are operating with this portion of the statute pretty frequently. So I point that out just because I think it's important to remind ourselves that oftentimes that definition of the word Indian fluctuates from federal statute to federal statute, and this just happens to be the one from the American Indian Probate Reform Act. Another definition that you need to know for purposes of the American Indian Probate Reform Act is the term eligible heir. We're going to talk about eligible heirs here in a little bit, but the definition that's set forth there in the federal statute is basically a person constitutes an eligible heir if the person is an Indian as defined, right? As we just talked about on those last three slides, if they meet those definitions, right? Or if the individual is a lineal descendant within 2 degrees of consanguinity of an Indian person as defined in the federal statute here, or co-owners in the same parcel of land as the decedent. That is the group of individuals who are recognized as eligible heirs under the statute. Any questions about that? Jim? Oh, yeah, that's awful. So consanguinity, and I probably say it wrong, that's how we say it in Oklahoma. So if you Google consanguinity, it'll come up with this chart, right? And it's basically showing you how you as a person are related to other individuals who are in your family, right? So 2 degrees, if we're talking about 2 degrees, we're talking about parents, grandparents, right? Or we're talking about children, grandchildren. That's for lineal ancestry, okay? However, it's possible to be within 2 degrees of other individuals who are not in your direct lineal line, right? So you can have an aunt or an uncle, right? You can have brothers and sisters. So there's this whole chart, and really it's a bunch of boxes that are stuck together, and you count from one box to the next, and that's 1 degree. You count from one box to the next, that's 2 degrees. So the best practical advice I could give is get that chart right off the Google. I should have put it in this presentation, but you can Google it, the chart of consanguinity, and it helps you, count the steps between people to figure out how an individual might be related to other people in that person's family. Okay, I'll tell you that under the federal statute, the American Indian Probate Reform Act, there are specific provisions for individuals who are related as half-blood relations. So when we're talking about like a half-brother or a half-sister, right, those individuals are treated the same as full sibling relations or full relative relations. That is actually something that's in this probate code, and I'll tell you, it's the same rule in Oklahoma. I'm not familiar with other states' probate codes enough to know exactly whether other states also recognize half relations the same way. But I will tell you the Uniform Probate Code does, Oklahoma does, Texas does. So, a lot of states are, this isn't much different than a whole lot of states. I think it's kind of the prevailing practice in probate code to treat half-blood relations the same as full-blood relations. Okay, the Act also defines trust personality, which is just your IM account. I mean, it's kind of a fancy word. I wish they'd just say it's your IM account, because when you say trust personality, I think that means something interesting, and then I find out it's just an IM account, and I think, why didn't they just say that? But Congress, they get paid by their fancy words, I think. Okay, so we know that that's the definition for trust personality, which is referenced a number of times in the Act, so I wanted to just make sure that you knew what that meant. Okay, any questions so far about definitions? All right, let's talk about intestate succession, because this is one of the ways that Congress sought to achieve the goal of reducing fractionation, right? Congress said this: most states have these intestate succession rules. So if somebody passes away and did not write a will, right, they're passing away intestate. And most states say if you pass away intestate, your property is going to be split among people who the state who passes the legislation thinks should inherit your property when you die if you didn't write a will, right? So most of the time it's going to be, people that just kind of make sense insofar as, relations to a decedent, a person who's passed away. So usually it's going to talk about things like a surviving spouse, right? Makes sense for a surviving spouse to benefit from the deceased spouse's estate. Most times it's going to talk about kids. If the decedent has kids, right, it makes sense that kids should be the ones to get parents' property. If you don't have kids, they start going back up the family tree and looking at things like siblings and parents. So the intestate succession scheme in most states under probate law is just a recognition that when a person passes away, those relatives that are most close to that individual are the ones who should benefit from that individual's property, right? So what was going on when we're talking about these rules of intestacy before the American Indian Probate Reform Act, what was going on was you had these American Indian trust interests being fractionated, because when a decedent passed away without a will, surviving spouse was going to get a portion, surviving children were going to get a portion. If there was a child who had passed away before the decedent, that child's children would get an interest, right? So you saw this really kind of fractionating, just more and more and more. And Congress wanted to do some stuff to stop it. So are you ready? We're going to talk about what they've done here, because I think it's kind of interesting. It's something that has just not been done anywhere else, right? There's no state law that does this under their probate code, so it's kind of interesting to see Congress being creative to try to figure out how to address this. Okay, what you need to know about the intestate succession schematic set forth in AIPRA is that there are 2 tracks, okay? There are 2 tracks for intestate succession. The first track is for any interest that represents more than 5% of the total land interest, right? So those more than 5% interests are on one track, and the less than 5% interests are on another track. And the reason for that is Congress said if we're talking about a less than 5% interest, that is a highly fractionated interest, and we've got to stop the madness, right? We've got to stop letting that continue to fractionate and fractionate and fractionate, because if it's less than 5% now, it keeps fractionating. It's going to be way less than 5% next generation, and just imagine how far that goes, right? So there are these two different tracks under AIPRA, and it's creative, and it's not something that you see under probate law in any other state. We've got the more than 5% intestate succession schematic, and then the less than 5% intestate succession schematic. So first of all, we'll go ahead and talk a little bit about what each of those tracks look like. I want to be very clear about something. If a tribe has passed its own tribal probate code and it complies with the requirements set forth in this act, you're not going to be using this act. You're going to be using that tribe's tribal probate code, okay? So it's helpful, whatever tribes you're working with, to figure out whether or not they have a tribal probate code that controls, okay? And keep in mind, when we talk about these tribal probate codes, the only tribal probate codes that are under the supervision of this act are those tribal probate codes that seek to distribute American Indian trust property. If it's just a probate code that a tribe has passed for personal property, right, for ceremonial property, for individual property that's not real property, not a land interest, those are not subject to the requirements of this act, and you're not going to be looking to those kinds of codes to deal with this stuff. So it's helpful to just kind of find out, number one, does the tribe have a tribal probate code? Number two, has it been approved by the Secretary of Interior, which is required under this act? And number three, is it set forth a different kind of schematic than what we're about to talk about here, right? Because it very well may. And I'll try to give you some examples of ways that tribes have deviated from what we're going to talk about the federal act does here in just a couple of seconds. Okay, so let's talk about that more than 5% track first, okay? When we talk about the more than 5% interest track, what I find whenever we look at the way that Congress set forth the property is supposed to be distributed, it's very similar to state probate law. It just is. It's very similar to what you see in Oklahoma, what you see in Texas, what you see under the Uniform Probate Code model, right? So it's not anything new. It's not anything dynamic. It's not anything super creative, right? Congress sets forth how they think property should be distributed for those more than 5% interests. Obviously, Congress wants us to look for a surviving spouse first. If there is a surviving spouse, the surviving spouse is going to receive some of the property, right? So the question is there a surviving spouse? And are there any surviving eligible heirs of the decedent, of the person who has passed away? Okay, so this slide shows you how it's going to be distributed if there is a surviving spouse and eligible heirs, right? The surviving spouse is going to get a third of the IM account and a life estate and all the trust property of the decedent, unless there are no eligible heirs. If there are no eligible heirs, the surviving spouse is going to get all the IM account, all of the money in the IM account, and then a life estate in the property as well. Okay, I want to point something out here because this is interesting to me. See, I guess I don't have a life because I think this is all really cool. Okay, so this is really interesting to me, the way that this federal act is set up to treat interests that are given to a surviving spouse, okay? If you're talking about a person who is going to get money out of an IM account, right? If the person is Native, the federal government sets up an account for the Native person so that they become subject to the same kind of beneficiary regulation as the decedent. But if it is a non-Native surviving spouse, that person gets a check, right? So when you think about the oversight for beneficiaries, non-Native surviving spouses are treated as, not trust beneficiaries because they don't meet the definition of Indian under the Act. I just think that's really interesting. I mean, I kind of think you should just ask, would you guys like a check or would you like us to put an IM account for you, right? Like, I'd check, right? Give me a check. Okay. All right. So if there's no surviving spouse or after the surviving spouse takes what the surviving spouse is entitled to under the statute, anything that's left over after that surviving spouse's share comes off the top. it's going to go to the decedent's children who are eligible heirs, right? So when we talked about that definition of eligible heir, it becomes important because it's not enough that an individual is a child of the decedent. You've got to double check and make sure that that child is an eligible heir. Usually they're going to be, right? But it's just kind of one of those weird catches in the statutory language. Now, this is what I think is really interesting. Okay. In equal shares. What does that mean? What does in equal shares mean? So surviving spouse gets what she's entitled to off the top. And then the remainder is going to be split among the eligible heir children of the decedent. So let's say there are 3. Okay, let's say there are 3, just for our example. So we've got 3 surviving eligible heirs, and they are to receive whatever's left after the surviving spouse share comes off the top, and they are to receive it in equal shares. What does in equal shares mean?
Divided by 3.
Right. It means divided by 3. In my mind, it does, right? Now, those of you who are lawyers in the room, when we learn property law, right? When we learn property law, we learn that there are a couple of different ways someone can hold property if they're holding it with more than one person, right? So you can hold it as tenants in common, which means in equal shares, right? Each individual tenant in common gets an equal interest in the property and can do with it what he or she pleases. But then there's this other idea of joint tenancy, right? And joint tenancy means we jointly own property. So if one of us passes away, the surviving one of us is going to own the entire thing, right? So when we think about tenancy in common versus joint tenancy, it becomes pretty important under the American Indian Probate Reform Act, okay? But when we look at the statute for intestacy for those more than 5% interests, and we see that they use the term in equal shares. As a lawyer, I see in equal shares and I think tenancy in common. Any lawyers in the room agree with me? If I see in equal shares, I think it means tenancy in common, okay? What's really interesting about this is even though it says in equal shares here, I'm seeing in the probate process, I'm seeing agencies actually say in equal shares in this context means joint tenancy. It's very interesting. We'll get to that some more in just a second, but as a placeholder, in equal shares here in the statute doesn't mean what we lawyers have always thought it means. It's being applied to mean joint tenancy, which is very interesting. Has anyone else been having that experience on the probate side? Anyone else seeing that? Like whenever it's an in equal shares distribution to a number of eligible heirs that it's going as joint tenants? Okay. Are you seeing it differently? Are you seeing it as tenants in common? I don't think it's uniform across the country. I think people are doing it differently. Okay. All right. So then let's talk some more just about this, again, more than 5% track whenever we're talking about how property is going to be distributed under the American Indian Probate Reform Act. Again, if we have a situation where there's a surviving spouse, that surviving spouse is going to take everything off the top. And then if there are surviving children eligible heirs, they're going to get everything, right? They're going to get the remainder split up in equal shares, but we don't really know what that means yet. If the decedent didn't have any surviving children eligible heirs, they're going to start going back up the family tree instead of down it. Does that make sense? So you're going to look to the decedent's parents who are eligible heirs, the decedent's siblings who are eligible heirs. And again, this is very similar to probate law for most states. The Uniform Probate Code, most states follow this kind of, your surviving spouse should get something, your kids should get something. If you don't have kids, take it back up the family tree to parents and siblings, right? Nothing super creative or interesting about this. Okay, one thing that is a little bit different in AIPRA that deviates from what you expect to see in state law, but if you think about it, it's really not that big of a deviation. When you look at a decedent who didn't have any surviving spouse, who didn't have any surviving children, who didn't have surviving siblings or surviving parents, right? What happens when that person passes away is that person's interests escheat to the tribe with jurisdiction over the property, right? Now that sounds kind of cool, right? It sounds interesting, but I just want to give you a spoiler alert. Under probate codes in states, the property escheats to the state in that same circumstance, right? If you don't have any relatives who are going to inherit under the statute, your property escheats to the state. That's a very common practice. But in AIPRA, they recognize that the tribe is the one who should benefit from the escheatment, not the state. But again, keep in mind, when we talk about escheatment to the tribe, it's not necessarily the tribe where the individual decedent was enrolled, right? It's actually the tribe where the property is located, which is a protection, right? It's a protection to make sure that other tribes don't own property in another tribe's jurisdiction, right? So it makes sense, but just keep that in mind if you're advising a tribal client, that when you talk about property either going to the tribe through this eschewment provision or being left to the tribe, because a lot of my clients want to leave their property to their tribe, we have to have a conversation about where the property is located, because that's what matters, not where the person is enrolled, right? Any questions about that? Okay, so this goes really far down the rabbit hole to try to figure out what happens if they just can't find anyone to give the property to. I don't see this operating ever, because there always seems to be somebody for the property to go to. But as a catch-all provision, Congress went ahead and said, if you can't find the tribe, if the tribe's been terminated, right? If you can't find the tribe, then look to provide the interest to co-owners or to the United States as a last resort. Okay. So that was the more than 5% track. Any questions about the more than 5% track? Yes.
I had a question about whatever going to the tribe.
Mm-hmm.
So what if it's an IAM account with money,
Sorry.
and they earn interest in different reservations that are earning that money into one account?
Ooh, that's a good question. Okay, I'm going to repeat the question just for the recording, okay? So the question is, if the decedent has an IAM account and is receiving funding for property producing income from more than one tribal jurisdiction, who gets the money that's sitting there in the IAM account? How do they do a calculation to figure out if it's an eschewment to the tribe, how much each tribe is going to get? That's your question, right? That's a great question, and I have no idea. Probate folks in the back, if you don't mind me calling on you, have y'all experienced that where you're making a calculation to figure out exactly which tribe is going to get what interest? Have you guys dealt with that? That would be a great law school exam final question. I love that. I'm putting on my final this year. Have you had that experience? Oh, I'm not doing a good job because there's a microphone involved.
So I did not announce this, but please wait for the microphone because it is being recorded, so
Sorry.
they can't hear you otherwise, and I apologize for not mentioning that in the beginning.
I can tell you, I'm from the Creek Nation, so I'm in Oklahoma.
Mm-hmm.
So we have trust, and some of ours have trust in restricted property.
Mm-hmm.
So if they have both, and we do a trust probate, and they have monies that are from separate tracts, OST distributes, they will divide it. They will distribute only the money that comes from the trust property with the trust probate.
Mhm.
And then once the state probate
Yeah.
part is done, then they distribute that money with that. I would guess, I have not had that, but I would guess they would do the same.
Yeah.
Because OST can go in and they can see where the money comes from, so they know what tract it comes from. So I would guess that they would distribute it accordingly.
I
to
would
each
think
tribe.
so. I would think you're exactly right, that they do some calculation to make sure that it's fair. But I mean, if you work at a tribe, you want to make sure, right, that that's happening, that the accounting is accurate, that the tribe is getting the full amount that the tribe is entitled to. Again, this is for those very limited circumstances where a decedent passed away and didn't leave someone who would otherwise get the property, right? So we're talking about a very limited number of cases. I have no idea how it works in actuality, but my guess is that there is a calculation done based on, the reports that they get on what is being produced from which parcel of property. Oh.
Get my steps in today.
I could sing to you guys in the interim if you wanted me to. I'm a terrible singer. Okay.
So I'm in probate and not OST, so this is just a general knowledge that I have. When we submit a probate, we have to calculate a dated death balance. And so I think that's treated differently than any interest that's earned after the date of death.
That's a good point. So when a person passes away, right, that is the date at which calculations are going to be made. But what's interesting is when we talk about the probate process that happens over OST, when we talk about the probate process, they're oftentimes not getting around to that decedent's probate until months, and in some instances years, after the decedent has passed away. So what they have to do is they have to get the date of death of the decedent and then look at income that's been produced on the property as of that date, right? Because that's the money that's going to be distributed. Anything that has accrued in the account from the date of death forward is going to be treated as income to the beneficiaries once the new beneficiaries are determined under the probate. So it's interesting because if you could just, if you could just do probates in real time, it would make it so much easier, right? But oftentimes they're going back 2, 3, 4 years to say, okay, we've got to take everything that was in the account as of the date of death and treat it this way, and then we've got to take everything forward and treat it a different way. So it gets very messy. Thank you for that point. Appreciate it.
Yeah, I'm from Colville. I just had a case where there had been income from 2 agencies, and before the decedent passed away, he had asked for a distribution, so the judge couldn't determine where it had came from. So he said that Congress had not made that determination yet until they made a law. He was leaving the money in the account.
And wouldn't give the beneficiary distribution?
No.
That's interesting. And I really wonder about that, because if we're looking at our ITIs, right, our individual trust inventories, if we're looking at those and we're looking at our IM account statements, we should be able to make a determination about which parcel of property is producing what. And I don't know that it would require any kind of specific federal authorization because it's an administrative process, right? Although, there have been a number of problems with record keeping and such, so maybe a judge just doesn't want to touch something like that. But that's an interesting case and frustrating, right? I mean, for a beneficiary not to be able to access the resources that the beneficiary has sitting there. That's really unfortunate. Okay, any more questions about the more than 5% or more comments or more points? Okay, let's talk about the less than 5% interest real quick. So like we said, that more than 5% interest stuff, very similar to what you'd see in probate law. This is where it gets really creative. This is where Congress does something different for Indian trust property. When we're talking about a less than 5% interest, Congress says we can't have that same approach of finding everybody who might possibly have some reason to inherit property. We can't do that anymore. We don't need to be looking all over the place for people to take property. Because when we start looking all over the place, we're fractionating, right? We're making it worse. So Congress says for those less than 5% interests, we're going to treat them totally differently under intestacy, right? So if a person passes away without a will, all of that person's less than 5% interest will be distributed like this. They're going to look again to see if there is a surviving spouse. If there is a surviving spouse, they're going to look to see if the surviving spouse is living on the parcel of property that represents the less than 5% interest. Now that sounds weird to my ears, right? If the decedent owns a less than 5% interest in a piece of property and there's a house situated on top of that less than 5% interest, really the decedent would only have a less than 5% interest in that, right? So the only time Congress says a surviving spouse is going to get to benefit from a less than 5% interest is if the surviving spouse needs to stay there to live in a house that's on that property, that's situated on that property. If there's no house, if the spouse is not living on that land, what's going to end up happening is she's not, and I say she, pronoun interchangeable, of course, depending on which spouse predeceases the other. But when we talk about a surviving spouse interest in the less than 5% track, it's much more limited. It's not like they're going to get a life estate forever. It's not like they're going to benefit from the property to the same extent they would on a more than 5% track. Really, they're only going to be able to have that life estate if they're living in a home situated on property where the decedent had a less than 5% interest. Has anyone ever seen that happen in real life? Have you seen someone have a house on top of property that they only had a less than 5% interest in and they were still occupying the house? Have you seen it? A couple of people saying yes. I've just not seen it. I've not seen it in Oklahoma, but that doesn't mean anything. Okay, so when we're talking about what happens after we check out that surviving spouse situation, anything that's left over after a surviving spouse gets whatever that surviving spouse might be entitled to. The property is going to go to the decedent's eligible heir surviving child. But if the decedent left more than one child who is an eligible heir, the interest goes to the oldest of them. So rather than seeing this further fractionation based on going to all of the different kids in equal shares, right? What we see is Congress saying, if you got more than one kid, only the oldest gets that less than 5% interest, only the oldest child. So when we talked a second ago about tribal probate codes, about tribes doing something a little different because maybe they don't like the way this is set up and they want to do something themselves, like under their own law, I've seen a couple of tribes try to change this eligible heir surviving child. I saw one tribe draft a code. It has not been approved, so it's not in force yet. But I saw one tribe draft a probate code where they said on our less than 5% interest, rather than giving the interest to the oldest eligible heir, we want to give it to the youngest, right? Like I've seen tribes do that, looking to maybe, still effectuate the purposes of AIPRA, but do it a little differently than what the federal probate code would have done. So you're going to look to see if the decedent left an eligible heir. If they left more than one eligible heir, you're going to only give the interest to the oldest one of them. If there are no surviving children who can count as that oldest eligible heir, you're going to look for grandchildren, okay? And if you can't find any grandchildren in the line of descendancy from the decedent, you're going to look to the surviving great-grandchild, okay? So this is another way that it's a little bit different, okay? It's different than that more than 5% track because we're talking about I'm looking for kids, I'm looking for grandkids, I'm looking for great-grandkids. If you don't have children, grandchildren, or great-grandchildren, that's it. They're not going to go back up the family tree and look for parents like they did on those more than 5% interest. They're not going to go back up the family tree and look for siblings like they did on that more than 5% interest side, right? So we're looking at a much more limited scope of individuals who can inherit via intestacy those less than 5% interest. Again, AIPRA is an attempt to try to consolidate, not further fractionate. So if we don't have any surviving children, grandchildren, or great-grandchildren, the tribe is next in line to inherit that highly fractionated interest, that less than 5% interest. So it's kind of interesting, right? You see this situation come up, and I'll tell you, at least 75% of the wills that I write in the American Indian Wills Clinic at Oklahoma State University School of Law, at least 75% of them are clients who are avoiding this. Clients coming to me and saying, I don't have any children, grandchildren, or great-grandchildren. I do not want my property to escheat to the tribe. I want to write a will so that my sister can have my property. Do you see what I'm saying? That's the majority of clients that I get in the clinic is clients coming in and saying, I want to write a will because if I write a will, I can do whatever I want with my property. If I don't write a will, I'm going to be in this situation where someone outside of my family ends up benefiting from my property. So that's a big reason for individuals to want to write wills in my practice anyways. Yes. Oh, one sec. We'll get the microphone back to you, sir.
I just had a question from Colville Tribe, and we have land owned by different tribal members from a different tribe, and when it went to probate, it was probably less than 5%, and now the land on a Colville reservation says it's owned by the Nez Perce tribe. So does it go back to the tribe that person was enrolled in, or to the tribe where the land is?
It is supposed to go back to the tribe where the land is, in the tribe's jurisdiction. So it shouldn't be under the name of another tribe pursuant to the federal statute. That might be a question you want to call and have a conversation about. You also might want to know what the mechanism was for the transfer. Was the mechanism intestacy? Was the mechanism a will, right? It's possible that the person wrote a will and wanted to name their tribe of enrollment as the beneficiary of the property, but that shouldn't be happening either, right? It really shouldn't. So I would definitely visit with your counsel, visit with the tribal attorney, and figure out how that might be asserted, because that seems like a problem. It does. Any thoughts or questions about that? Keep in mind that my views do not necessarily represent the views of the Indian Land Tenure Foundation or the Tribal Land Association. It's just me freewheeling up here. Okay. All right. Any questions about those less than 5% interests? Do you see, though, that it should work, right? Like what Congress did here, it's creative. You don't see it in other probate law. but it should work, right? It's something that should work. The idea being, of course, most American Indian trust beneficiaries don't write wills. And when they don't write wills and their estates go through the probate process, applying this schematic to their interests rather than a schematic that exacerbates fractionation, it's something that should work from a creativity perspective. Yes.
And this may be jumping ahead, but when you have less than 5% and it's going to escheat to the tribe, can a co-owner still opt to
Yes.
purchase it? Okay.
Yep. And I want to say the statute authorizes it, okay? But this is all left in the hands of judges, right? And it's all left in the hands of people fighting back and forth. And I can't tell you what a judge is going to do. I mean, I just can't. I never know, right? Things that I look at the law and I think are very clear, and it's just kind of an administrative paper trail that needs to be developed. You go to court and it ends up getting completely blown out of the water. You just never know what's going to happen in a situation where there's a contest, where there are two people or two entities that are contesting how things should go. You just never know. But the statute authorizes it, yes. Okay. Oh.
So I'm a rookie at all this, but I've heard the term Indian will and a will, so that Native Americans need to have two wills. Are we going to get to that?
We can talk about that. Sure. We'll talk about that. I have some slides here in just a few minutes about wills. Let me get through this exception real quick, and then we'll start on the wills thing. Okay. So let's talk about some differences in the American Indian Probate Reform Act that I think are just interesting to highlight, right? An individual who is going to get an interest in a decedent's property, an individual can renounce receiving that property, right? It's like hot potato. Nobody wants this property, right? So an individual can actually renounce his or her interest in favor of another eligible heir or another person who meets the definition of Indian set forth in this act who's related to the decedent by blood, but only to one person, not to multiple people in equal shares. The individual can also renounce the interest in favor of a co-owner or the tribe, right? So in instances where there are individuals who are the oldest eligible heir for these highly fractionated parcels, that individual eligible heir can say, you know what, I don't need that less than 5% interest. I'm renouncing my interest in that in favor of someone on this list, right? That's authorized by the statute again. And I've seen renunciations. They're very few and far between, but I've seen them in my practice, so I know they happen. Okay. We don't really need to talk about this. For the lawyers in the room, the simultaneous death rule under AIPRA is 120 hours, which is a lot different than what you see in probate codes in states. So I'll just point that out because it's weird. Yes. 1 second. We'll get a microphone back to you.
Keep your hands up if you would, so that.
So I don't know if this is really even a question, but so that person renounces their part to, say, their family or sister or whoever, and then that new person has other family, so that's going to fractionate anyway.
So it's not going to further,
Eventually, or-
sure, it's not going to further fractionate that one interest, right? It's not going to as to that one interest. But I totally see what you're saying because it's actually just kind of kicking the can down the road and it's not achieving consolidation. I'll tell you the renunciations that I have seen have achieved consolidation because it's somebody saying, oh, I'm going to renounce my interest in favor of my sibling because my sibling already inherited interest in this property from another part of my family. Do you see what I mean? So I have seen renunciations effectuate consolidation, but they don't have to under the statute. So that's a good point. They don't have to. But they won't further fractionate. You're just kicking the can down the road for another generation kind of deal. Yeah. Okay. Any other questions? All right. Let's talk a little bit about will drafting because I think this is some interesting stuff. I hope so. I hope it's a little bit interesting. So when we look at the statute, if you read the statute, what we've just talked about are the intestate provisions of the probate code, right? There are also wills provisions of the probate code that we need to talk about, because if we're going to be drafting wills for individuals to get out of this intestate succession schematic, and most of my clients want to do something different than what the schematic would do to their property. If we're going to be writing wills, we need to make sure that we're familiar with what the requirements are for them to be valid under the federal code. Because as lawyers, we think we know how to write wills, and we do, but we know how to write wills pursuant to state law where we practice. And there are requirements that are very specific as to trust property that need to be followed in order to make sure that you're writing a will that's going to be valid and going to be recognized by the department whenever the probate is done. Okay, the question we got right before this was about whether individual Indian people need to have multiple wills. And I'll tell you, my answer to that is no, right? My answer to that is, as a lawyer who writes wills, I need to be able to write a will that serves all the purposes my client needs. And in Oklahoma, I'll tell you, in my practice area, in Oklahoma, I have a whole lot of clients who own fractionated interests in Indian trust property in the state of Oklahoma, but they also will own like a house, right, in town that's not on their trust property. I need, as a lawyer, to be able to write one will, right, that disposes of any interest that that person has in non-trust property, any interest that person has in personal property, and I need to make sure that my will complies with these requirements in AIPRA to dispose of their trust property. So my practice, the way I teach my law students is you need to write one will for this client, and that will is going to be probated in multiple places. So make sure it's a good one, right? That doesn't mean that everybody does it that way, right? I've seen a lot of lawyers outside of the state of Oklahoma who will go ahead and write different wills, who, write one will for the real property and the personal property that's not in Indian status, and then they write a second will that disposes of trust assets. I've seen that happen. The problem is, right, those wills have to reference each other, and they have to work together, because your non-trust property will has to say something like, this specifically does not dispose of my Indian trust property. No residuary clause in my will should touch it, right? This will over here on the trust property side needs to say, this will does not, affect my non-trust property. The wills have to reference each other. The problem is, if a client wanted to revoke one, right, it could potentially have a revocation impact on the other. I just think it creates too many legal problems to do two separate ones. So I think, writing one is ideal, but you got to make sure the person writing it knows how to do all of those things, because it's different law. It's different law. So what I think is really interesting on the probate side when we're talking about these wills is that they're certainly going to be probated more than once, right? They're going to be probated under state law. They're going to be probated through the Department of Interior process for those trust property interests. So we're really talking about clients going through a whole lot of work to get through this. Okay, so let's talk about will drafting just really quickly. When we look at the will writing provisions of the American Indian Probate Reform Act, they have some requirements that we need to know about because they're different than writing wills for other folks. So when we have a will that we're going to write for a client who owns an interest in trust property, client comes to my office and says, I want to give my trust property in my will to my kids. Fine, you can totally do that, right? You can write your will and you can give your property to whoever you want. If a client comes to me and says, I want to leave my property to my friend, right? I have to say, is your friend an American Indian person, right? Because the statute tells us the only way you can devise your trust property to another person and it still remain in trust status after you pass away is if you devise it to a lineal descendant, a co-owner, the tribe, or an Indian person. And when we use the term Indian, it's the federally defined term in this act, okay? So when we think about writing wills for individuals, we have to make sure that we advise them of that, right? Because I've had multiple clients say, I want to give the property to my friend. And I say, is your friend a Native person? Nope. Okay, well, you can totally leave your property to a non-Native person. But if you do, it won't be trust property anymore, right? It goes into fee status, which means it's not Indian country, right? It's not Indian land anymore. And I'm telling you, 100% of the time when I have that conversation with a client, my client says, whoa, never mind. I don't want it to fall out of trust status. I don't want it to not be Indian land anymore. So a couple of things you can do for the client. These are authorized by the statute, okay? the client can actually give a non-native person a life estate in the property. And so long as the remainder after the life estate vests in someone who is an Indian person as defined by this act, it'll stay in trust status even during the term of the life estate, right? So, I mean, I can do that for a client. I can say, hey, we'll let your friend benefit from the property. We'll let your non-native friend benefit from the property throughout her lifetime. But after she passes away, we're going to make sure that remainder goes back into ownership by an Indian person. It'll stay in trust status the whole time. So that's kind of cool. But it's different than what you would expect in other probate codes, right? So here we have this slide that talks a little bit about that life estate. Again, so long as the remainder vests in somebody who the statute considers to be Indian or eligible to own Indian land, it won't affect the trust status of the property. Any questions about that? It's just an estate planning tool that we have that's available since this is kind of weird and treats American Indian trust property differently. Okay. Okay. There are instances, I have only had one. Okay, I've written over 1,000 American Indian wills in my lifetime. I have only had one person tell me, I do not want my property to stay in trust status. I want it to go in fee. I've only had one person ever tell me this. So this is authorized under the statute, but it's really interesting because if an individual client wants to devise property in fee in her will, it can go to a lineal descendant or a co-owner, and as long as we put language in there that says, I specifically don't want this property to continue in American Indian trust status, I specifically want this device to go in fee, right? As long as we include that language, it's cool under the act. But what's interesting is, if we're talking about that person wanting to give property in fee status to anyone other than a lineal descendant or a co-owner, it's not authorized by the statute. So you can't leave your property in fee to the tribe. It's just interesting. It's another one of those weird catches, okay? So let's go back to tenancy in common and joint tenancy, okay? Remember, we talked about tenancy in common is when more than one person is going to benefit from a property interest. But in tenancy in common, each of those individuals, again, we'll go back to our example of 3 people. Each of those people get a 1/3 undivided interest in whatever you owned, right? On the other hand, when we talk about joint tenancy, it's joint ownership with the right of survivorship. And what that means is if more than one person owns it, the last one standing at the end of the day, right? The last surviving owner gets the entire interest, right? So when you think about like buying a house with a spouse, right? Typically those deeds are joint tenancy deeds, meaning whichever spouse outlives the other one gets the whole thing, and it's not going to be subject to being split up as a tenancy in common would. So when we talk about AIPRA, one of the kind of cool things that they've done that's different, it's totally different than what you would see in probate law in states. Okay, under probate law anywhere else in the world, okay, if a decedent writes a will and says, I leave my property to my 3 kids, period, right? Under every other probate code in the world, it's going to be interpreted that that testator left the property to his 3 kids as tenants in common, meaning each of those 3 kids gets an undivided 1/3 interest in what the testator left them, right? Under AIPRA, if you write a will that says, I leave my property to my 3 kids, period, there's a presumption that the testator intended to leave it as joint tenancy property. It's just totally flip-flopped and backwards from what we would expect under state law. It's totally different, right? Again, this effectuates one of those ideas that Congress had about how to reduce fractionation. Because if you think about it, giving something to 3 kids as tenants in common further fractionates. Giving something to 3 kids as joint tenants, you don't further fractionate because the last one surviving gets the whole interest, right? So it definitely achieves one of those things under AIPRA, one of the purposes of AIPRA, but it's just totally different than what we would expect under any other area of law. Any other state would look at a presumption of tenancy in common rather than joint tenancy. Any questions about that? Got one right over here.
So what happens when it's greater than 5% intestate? Is it?
I don't know. Right. That's what I'm kind of weirded out by, because what the statute says is it says in equal shares, right? And as a lawyer, anytime I've seen N equal shares, I think that means tenancy in common. That's what I think it means. But what I'm seeing on the probate side is I'm seeing some probates come through on those more than 5% interests where it should be N equal shares, but it's going as joint tenancy, right? And I call and talk to the folks at OHA. Actually, I talked to OHA and I'm like, what's going on with this? Because when it says N equal shares, I thought that meant tenancy in common. And I get told, no, it doesn't mean tenancy in common. It means joint tenancy. And so then my mind did like these weird gymnastics things because I was trying to figure out how you could have a joint tenancy in equal shares. Like I just don't understand legally how that works. So I'm seeing it. I'm kind of curious to see if that's how it's being done in other areas. But I'm seeing on some probates that they're interpreting the N equal shares on those more than 5% interest as joint tenancy, which I think is interesting. So I don't know if that's a national standard, if that's a national practice and that's their interpretation of the statute, or if it's on a case-by-case or area-by-area basis. I don't know. Does anybody know? Has anyone else had experience with this? I'm seeing a strong preference out of OHA on joint tenancy. I'm seeing a strong preference for it, which I get because it, keeps things from becoming fractionated. But I also, I have a lot of clients and a lot of my clients don't want this. I have clients who come in and write wills on highly fractionated interests, right? It'll be a 0.000067 interest in a piece of property. And I say, client, how would you like to leave this property? I want to leave it to my kids. Okay, client, there are a couple ways you could do that. They could be tenants in common or they could be joint tenants. I'm telling you, 99% of the time my client says tenancy in common. I want it split equally among my kids. And I always have a conversation about that, right? I say, client, you realize this is going to further fractionate your interest. Each of your 6 kids is going to get 1/6 of that 0.000034 interest or whatever, right? I'm telling you, my clients 99% of the time tell me, I don't care, I want it as tenants in common. Now, I have a duty to represent my client. I'm going to do whatever my client wants, right? That my duty is to my client. My duty is not to make sure Congress gets their way with reducing fractionation, right? Like I write the will how my client wants it. But I'm telling you, it's really interesting to see that the majority of individuals would rather see it further fractionate, right? That's how they want their property to go to their kids. So when I start to see on the probate side this weird treatment of the N equal shares as joint tenancy, I just wonder if that's really what individual people would want. I just wonder. I don't think it is, just from my experience. I think they want to see, which is why they come write wills, right? What? Oh, I'm sorry. OHA is the Office of Hearings and Appeals. Sorry. Wait, just one second. We got a microphone coming to you.
I was going to use my theater voice, but okay.
I love it. Well, they're recording, and the people on the recording need to hear us too.
Okay. So this is not my area of practice, but I have a theory about why that may happen. And it comes from my general practice, and that is that the general population outside Indian country tends to think of joint tenancy as, I own half the property, it's just that I can get the whole property.
Yeah.
And I'm wondering if that's how it's being interpreted, even though as a lawyer, it just makes me scream inside.
Right. And I'll tell you, one of the things that I work on with my law students very early on in the semester, I want them to be able to explain the difference between tenancy in common and joint tenancy, and I want them to be able to explain it so that any of my clients could understand it, right? And as lawyers, we use these terms all the time, but before as a lawyer, I never heard those words. I didn't know what they meant, right? So I think it's really important that when we do estate plans, we make sure that we explain exactly how these different property things can occur, because it doesn't make sense. It's not intuitive. It's not something that you deal with all the time. So it's really important that clients totally understand the differences because it matters for purposes of their will. So because of this presumption of joint tenancy stuff that goes on in AIPRA, my recommendation is when you write a will, if your client is leaving property to more than one person, spell it out. Spell out exactly what the client wants. Do they want tenancy in common or joint tenancy? I require my wills clinic students to include one of those options on every single will. So the provision would say something like, I leave my trust property to my 3 kids as joint tenants, if that's what the client wants. Or I leave my trust property to my 3 kids as tenants in common. whatever the client wants. Because if you don't put it in there, they're going to run it joint tenancy. They will absolutely presume joint tenancy, which is backwards from every other area of law. We have a question back here.
Do you know how the OST tracks joint tenants? Like, how would they split up the interest coming in, or is it noted somehow on their accounts?
Yeah, so it's definitely part of their tracking. It's part of the way that they identify the property. In fact, if you look at the land description, right? If you look at the land description on an inventory, there's a different letter code to demonstrate that it's joint, right? So if you're reading an ITI, if you guys are coming to any of my sessions later in the day, I actually have an ITI and an example that we're going to use in a will drafting exercise. But when you look at the property codes, you can actually tell whether it's joint or whether it's tenants in common, which is really interesting. But you got to know how to read them. You got to know which code means what thing. And by the way, sometimes they change the codes and they don't tell anyone. So that's not funny either. You know, like I have my way of reading them and I don't know really what they say sometimes because they change the codes. But I know it's all hard and we all do our best. So when we're talking about income derived off of the property on a joint tenancy, the income is going to be treated as joint income as well, but subject to, you know, withdrawal requests by beneficiaries, either one. Interestingly, they're not going to separate or segregate it out. So as a joint tenant, I would have access to the entire amount of money that is produced on the property, as would my co-joint tenant. So hopefully you trust your joint tenants, right? I mean, it's crazy. It's not good. Okay. Any questions, any more comments about that? You guys have stuck with me. I really appreciate it. There are some interesting provisions in AIPRA. We don't need to go into excruciating detail on it, but I'll just tell you it's very much the common practice under probate codes. If you write a will and after you write a will, you got divorced and then you pass away before you have a chance to go write yourself another will, AIPRA sets up a schematic so that a divorced spouse won't inherit property from an ex-husband or an ex-wife's will. That's just good policy, right? Like if you got a divorce, you probably don't want your ex to get your stuff. You can overcome that. I've had a couple of clients come to me and want to make sure that their ex-spouse receives something in their will. If you have someone like that, you just need to make it very clear. I recognize today that I am divorced, but I still want my ex-spouse to inherit. You just make it very clear in the will and it's fine. But that is a protection there for individuals who get divorced after they write a will and then don't correct their will before they pass away. If there's still a spouse listed in a will and the individuals are divorced, what they do is they treat it as if the spouse predeceased the person who passed away. So the person gets nothing. Okay, let's see. Another interesting function of AIPRA relates to pretermitted children. This is when you write a will, and after you write the will, you have a kid, right? And then you never go back and amend your will before you pass away to reference this new addition to your family. It happens quite a bit, right? It could be birth or adoption. So there is protection for kids who come after a will. If a kid comes after a will, the kid can actually go in and say, hey, I was left off the list because I wasn't born yet when the will was executed, but I'm here and there's no reason not to give me a share as my brothers and sisters also are receiving a share, right? Unless the testator specifically says, I'm making no provision for children born after the execution of this will, right? A testator can do that. A testator can say, sorry, if I have kids later, you're left out. I've never had a client want to do that, but I'll tell you that it's an option under the statute, authorized under the statute. Okay, and another interesting facet, and again, this is one of those areas where I think tribal probate codes can do something a little bit more tribally, culturally, community appropriate, right, than maybe the federal statute does. Because it's not the same practice everywhere, right? When we talk about children who are adopted, if a child was the bio kid of the decedent and the decedent gave the child up for adoption, the child is not considered to be the heir of that decedent. But if a child is adopted in by a decedent, the child is considered to be a descendant as long as there is a legally valid adoption decree. So under intestate rules, adopted kids are treated differently. If you're adopted out, then you're not going to share in the distribution of the decedent's estate. If you're adopted in, you will. I will tell you, I've had a number of clients not like that. I've had a number of clients come to me when we're writing their will and say, when I was younger, I had a child who I placed for adoption. I still want that kid to inherit part of my estate. I've had that several times in the wills that I've drafted. So it's just not, this practice doesn't necessarily reflect the community or cultural practice of individual tribal folks. So it's really important that we know that this is how the law operates, because we need to get around it, right? I have a lot of clients who say, I still want the kid that I placed for adoption to inherit my estate. Still want that person to inherit a portion of my estate. So keep that in mind, because it's a little bit different than what you might expect. Okay, that was a lot of information. You guys stuck with me. Thank you so much. It's first thing in the morning. I know it's hard to listen to all this dry stuff, but I appreciate everyone sticking with me. Are there any questions?
So just for clarification, it's 5% or greater?
Right.
correct? Okay. And then why 5%, or do you have any insight?
You know, when Congress was putting the statutory language together, they had to kind of figure out where the tipping point was on the real problematic issues, right? And when we're talking about the number of interests that just kind of blew up, where we're managing interests that produce, 5 cents of income in a year, right? And we're having to write a 5-cent check and put a stamp on it. They just figured out where that tipping point was, and where it started to be like just unmanageable and super concerning was at that 5% rate. So that was just kind of an administrative tipping point setting. But I will tell you, I think Congress was also wanting to make sure that they would not get this statute struck down as unconstitutional, because they'd had 2 turns at bat, right? They'd had 2 turns at bat with the Indian Land Consolidation Act. Both times it was unconstitutional. I think they had to be able to demonstrate with statistical data, right? They had to be able to demonstrate this is a problem that we need some kind of extraordinary remedies for. And I just think it would have been a tougher sell to get through litigation if they tried to do it at the 25% tipping point or the 50% tipping point. You know what I mean? So I think it was just kind of their best effort. You never know. I mean, once they see how this works over a number of years, it's possible that they'll go in and try to open it back up and slide that up. It's totally possible. But I don't know. It'll kind of depend on how their statistics play out. We'll have some conversations in a session later today. Do you remember which session we're going to talk about probates? Jim? I think the session after lunch, we're going to do a little bit on probates and talk about that crazy administrative burden, because it's when you start to see how much each probate costs and how long it takes, and we're talking about teeny tiny interest. I get it. I understand why Congress felt the need to intervene. I mean, they could have,
So the next session is implications of AIPRA, and then
Yeah.
the following one.
The next one
And
after
the last
that-
one is the will draft.
Yeah, we're going to draft some wills in the last session. I had one more question over here. Oh, I have two more.
Thank you. On the less than 5%, whenever a tribe comes in on the less than 5%, and in western Oklahoma, tribes cannot sell their trust property. So what does this do to that property when the tribe comes in on it, and the other heirs that own the other 95% of it would like to sell? Does that mean the tribe can't sell theirs, and so they'll never be able to buy? Whoever buys it would not be able to get 100% of the property.
So I think that's just going to depend on who is buying the property, right? I mean, I think when we're talking about the likelihood of getting approvals on a transfer, they're wanting to figure out exactly who's going to be buying the property. So are we talking about selling it out? Like, are we talking about selling it so that it's not in trust status anymore, so that it's no longer considered Indian country? Or are we talking about maybe the tribe itself buying 100% interest?
Well, actually, it wouldn't be an issue if the tribe bought it.
Yeah.
But if another individual wanted to buy it, or they wanted to sell it to another trust, Indian individual of the same tribe, then the tribe would still own that less than 5%.
I see what you mean. Yeah, I see what you mean.
So they would never be able to sell 100% of that, so that the person will never gain that part since it's undivided. So-
Yeah. And I don't know how you might be able to effectuate a transfer. I mean, if you're looking at not doing it here, right? I don't know how you might be able to effectuate a transfer. Of course, it's always going to be subject to that approval, but there may be a way to do it if it achieves consolidation. Maybe you just have to go try to sell the idea of consolidation to the folks who might be able to give approval on it, right? But yeah, I see that as being problematic because if you're talking about someone who can own 95% of the interest but not 5%, it really does reduce the value of the property, right? As to an individual property owner. In reality, tribes want to own property too. So, I mean, I see that there's a tension there, but I do definitely see that reducing property value from an individual perspective, for sure. Any other questions? Oh,
Wait, you want to follow up? Okay.
oh, thanks, Jim.
About the only way that you would be able to address that remaining portion that's owned by the tribe would be to trade. Most tribes have a restriction on sale of property, but that doesn't preclude you from being able to take a parcel that the tribe may have a different interest in and trade them so that you can gain that extra 5 or whatever % the tribe may own. Again, it's the sale restriction that affects the tribes, but it's not a trade restriction. Most tribes could trade you different interests to affect that.
What about gift? What about by gift? Is that an option too?
Most of the time, tribes cannot dispossess.
Yeah. Bummer.
Do you have a follow-up to this?
Yeah, I was going to say, yeah, the Creek Nation, less than 5% was cheated to the tribe, and they tried to give it back to the siblings of the decedent, and yeah, that was struck down.
Was it really?
Yes.
Interesting.
Couldn't
By
do
gift
it.
even, not even by
yes.
sale.
We just they did a tribal resolution to give it back, and then they said no.
Isn't that interesting? Yeah.
Yeah.
I have a succession question. So I just want to be clear in my mind. If you don't have a will, then we go through the succession. If we do have a will, the owner of the interest could give it to anyone in their direct line.
They can give it to anyone, period, anyone, but it'll only stay in Indian status and be trust property as long as it's going to a native person. If it goes to a non-native person, it loses its Indian status.
And the person, he or she, can decide whether it's in common, tenants in common,
That's
or
right.
joint tenancy.
That's right.
So you need a will.
You need a will. Yes. I mean, if you look at the intestate succession schematic and you're like, cool, that's how I want my property to go anyways, fine, great. But I'm telling you, all of my clients don't like it. So they come to us because they say, I don't want my property to go like that. I want it to go the way I want it to go. That's the whole reason we have the wills clinic. And I'm telling you, we never run out of clients. And we do them constantly. We never stop. So, I mean, it must be very problematic from a trust beneficiary perspective, because whatever Congress tried to do is not what most people want, which is interesting. Bless their hearts, as we say in Oklahoma, bless their hearts.
I'm coming.
I just had a question about the adoption. Now that a lot of tribes are starting to do customary adoptions, what is the succession rights there? Because most customary adoptions don't terminate parental rights and keep some of those succession rights. So does a child who's been adopted through customary adoption, they retain those biological inheritance rights, but then do they also inherit the adoption rights with the new family?
So yes, if parental rights haven't been terminated, right? But keep in mind, when this statute talks about adoption, they're looking for a valid, legally entered decree, right? It's really problematic when we think about what that might be interpreted to mean. My fear is if we had like a certificate, right, that is signed by the tribal court. For us, we recognize that as a legal decree, right? But I could imagine it being interpreted as not the same if it doesn't look like the same kind of a decree you'd get in a state court on an adoption. It's just that same old story of, a lack of respect for tribal court action, right? So I'd want to definitely try to make sure that you achieve what you want to achieve for a particular client when it comes to an adoption. If someone comes to you and says, I'm not sure how this is going to operate, maybe you can go ahead and go get like a court order to clarify it before the person passes away. Because my fear is after the person passes away, the interpretation of what adoption really means is going to get skewed out of the favor of tribal court action, is what I would imagine. Maybe I'm just pessimistic, but I've seen it, you know. Any other questions? Okay, there is a break till 10:30, and then another session starts. So thank you guys for spending some time with me this morning. I appreciate your attention, and I hope you enjoy the rest of the conference. Thanks.